ahead and be seated, please. First matter we'll take up this morning is Baxter County Case 2015-362, State of Arkansas versus Kyle Riggs. Mr. Riggs, can you hear me?
Yes, sir.
And are you able to see the courtroom as you sit there?
Yes, sir.
Very well. You're here before the court today. Have you for arraignment on charges of theft of property, a Class D felony, and commercial burglary, a Class C felony. On those charges, how do you? Well, first of all, have you made arrangements to be represented by an attorney?
I filled out the paperwork for the public defender since I've been in here, and other than that, that's all I've been able to do. I was hoping to get a reasonable bond and all my things if probation and parole would agree with it, maybe on an ankle monitor. I have a bed open at Care Center Ministries, and I was hoping, if at all possible, to make a bond and go there and get proper legal representation.
Well, let's do one thing at a time. First of all, about the legal representation, you have filled out an application for the Public Defender's Office?
Yes, sir.
Were you able to contact the Public Defender's Office at this point?
I have not met with them. I've been stuck here.
Mr. Cooper, were you aware of this application?
No, Your Honor, we were not.
All right. Well, the court will, of course, the court is somewhat familiar from past cases, somewhat familiar with your situation, and would anticipate that the court will be making the appointment of the Public Defender's Office in this matter. I'll ask Mr. Cooper to stand in at this point in anticipation of receiving that application and making the appointment. The charges, as I explained earlier, are theft of property. It's a Class D felony, and commercial burglary, which is a Class C felony. Are you prepared to enter a plea on those charges at this time?
Your Honor, we would enter a plea on his behalf of not guilty. We'd waive formal reading of the charges.
I'll note on the record a plea of not guilty and set you for a reappearance in front of this court on February 4th, all of 2016. Each of those dates that I gave out will be in 2016. Addressing the issue of bond. Bond in your matter has been set for set at this point at $5,000. Cash or professional bond. Court has seen and reviewed apparently there is a probation revocation warrants that are coming down as well, and at this time the court's not, until all of that is resolved, the court's not in a position where I'm going to reduce the bond from the $5,000 that's been set already. I'll make that the bond at this point, $5,000 cash or professional bond. We may be willing to work out an arrangement for you to bond out to attend the program that you were talking about.
Yes.
You know, something along those lines very well can be worked out. But until all the charges are established, what they're going to be, the court's not going to try to do it piecemeal. Let's do it all at one time. I'd also like Mr. Cooper to have an opportunity to get involved in your case and follow through on it. So that'll be the ruling of the court today.